I'm firearms attorney Gilbert Ambler, and I'm back today to talk about the machine gun ban. This is a subject that the internet has been ablaze talking about, and it's all because Judge Carlton Reeves, down in the Fifth Circuit, decided that 922-0, the ban on civilian possession of machine guns, was unconstitutional as applied to the facts before him in that specific case, which was United States versus Brown. In response to this decision, the internet has taken one of two paths. The first path has been commenters putting out essentially clickbait, saying things like NFA struck down and machine guns now legal, everyone can have a machine gun. And that is obviously not true. In response to these sort of untrue clickbaity spins on the decision, another set of YouTubers or gun tubers has come out saying, not only is that not true, but there's really not a viable path forwards to challenge 922-0. And I also don't think that's necessarily true. So what I want to talk about today is I want to talk about the machine gun ban and what a challenge to the machine gun ban 922-0 might look like if it were a facial challenge, meaning not asking the court to just strike it down for one individual, but asking the court to strike it down for everyone. And before we dive into this subject, if you have not yet hit that subscribe button, what are you waiting for? Like, comment with your thoughts, share with your friends, that way you and your friends can keep getting this important Second Amendment related content. All right. 922-0. And I agree, by the way, with all the commenters out there saying that practically speaking, there might not be a court that will strike this down facially. And I agree with that because even our Supreme Court, which currently has a conservative majority, is not necessarily looking sympathetic towards machine guns. And we say this in part based on the recent Cargill decision, where Justice Alito and his concurrence went out of his way to say, bump stocks do not fit the definition of a machine gun. However, Congress could do something. Congress could regulate bump stocks. And although he did not say it would be constitutional if Congress did that, given that he was talking that way, it seems implicit in his concurrence that he believed a ban on bump stocks as machine guns, if Congress did it, would be constitutional. And of course, he's not yet looking at the specific facts, so maybe if it were before him, he might decide differently. But it's not a helpful sentiment. That being said, from a legal perspective, I think there is a path to challenge 922-0, the machine gun ban, and I think it fits neatly into the Brune text, history, and tradition framework. What you will find in courts that have considered machine guns, however, is that many of them think that you don't have to reach text, history, and tradition. Instead, what they have typically been doing is they've been looking at Heller dicta. And keep in mind, dicta is not necessary to the holding of a case, and therefore is not typically binding, but is instead only persuasive authority, meaning a court does not have to follow dicta, even if it is Supreme Court dicta. That being said, there's Supreme Court dicta in Heller that talks about the types of weapons that are protected. They talk about bearable arms being protected. They then talk about the idea that there's protection for arms that are in common use. And they say that they believe that there is historical support for the tradition of not protecting arms that fall outside common use, such as the carrying of dangerous and unusual arms. So we have these terms of art here. We have common use, we have dangerous and unusual, and there's some interplay between those terms. One of the things that I do think is very, very important, however, is that I think the court has to arrive at a text, history, and tradition test, because this whole idea that an arm might or might not be in common use or might be dangerous and unusual flies in the face of the concept that if it is a bearable arm, it gets Second Amendment protection. So assuming it's a bearable arm, I think the court is going to have to apply the text, history, and tradition test. And notably, if this dicta always ruled the day, then there would never be any protection in any of the courts for felons. And of course, we know that's not true. Recently, the Third Circuit decided the Range case. So even in the Third Circuit, which is not a circuit known for being gun-friendly, judges can recognize that although there's dicta on a subject, when they actually apply text, history, and tradition, they might arrive at a contrary result. Turning back to the idea of common use and dangerous and unusual arms, I want to first look at the common use term, because the government likes to throw around the number of 176,000 machine guns in circulation. Where are they getting this number? They're getting this number from the number of machine guns that were in circulation on May 19th, 1986, when the Hughes Amendment went into effect, stopping new possession by civilians of newly manufactured machine guns. However, I want to note that there are, in fact, far more machine guns in the hands of civilians. What civilians, you ask? Civilians that hold an FFL. Because FFLs, federal firearms licensees, are civilians, and they are able to manufacture and obtain newly manufactured machine guns, provided they can get a law letter. Have a local police department or a law enforcement agency write them a letter saying they have a need for a machine gun to demonstrate for the department. So if they get that law letter, they can get a machine gun, and there are new machine guns being built every week by FFLs who have such law letters. So when you take all of those additional machine guns, which might have been built for the purpose of a demo for a law enforcement agency, but are not currently owned by a law enforcement agency, they are owned by civilian FFLs, there are far more than 176,000 machine guns in the hands of civilians. Why does that number matter? Well, in Caetano, in the stun gun case, the court referenced the fact that there were somewhere around 200,000 stun guns in the hands of civilians. Well, when we put all of those FFL machine guns combined with the 176,000 registered transferable machine guns, we have a number that will far exceed 200,000, and the implication from the court, at least in Caetano, was that they thought 200,000 possessed items was sufficient to demonstrate that an item was in common use. Next, we need to turn to the dangerous and unusual part, because if the government can show a tradition of banning an item as dangerous and unusual, potentially they could still uphold a machine gun ban. And I want to give credit where credit is due. This is not a really original thinking from me. Most of this credit goes to two people. The first is a Gun Owners of America attorney, Rob Olson, who has some of these theories. And the second is one of my associates and one of my colleagues, Oliver Kravchuk, who, along with me, has been writing an article for the Dickinson Law Review talking about this concept. And the concept is that the historical tradition that is referenced in Heller is a tradition of banning the carrying of dangerous and unusual items. If the ban is only on the carrying of dangerous and unusual items, and we're assuming for the sake of argument that the government can produce this tradition, because Heller didn't necessarily specify what constituted this tradition, and the court would still have to take a look at that, and it would still be the government's burden to produce that tradition. But if we assume for the sake of argument that they can produce a history of bans on the carrying of dangerous and unusual weapons, it still does not necessarily support a ban on the mere possession of such items, especially when they are possessed inside the home. So I think there is potentially still a path forwards to challenge as a facial matter broadly for everybody 922.0. And of course, if such a challenge were successful, there is the potential that civilians could obtain new machine guns without having to go through the FFL process and obtain a law letter. And of course, I do want to remind everybody, as long as you're eligible to possess firearms and not in a draconian state like New Jersey that I think bans machine guns, you can still possess machine guns today. They're just expensive, and they're expensive due to the artificial limitation of the number of machine guns in circulation. But if you want one, by all means, you should go get one. In the meantime, if you enjoyed this content, give us a like, give us a subscribe. Until next time.